Hello everyone, I am Aleena. The topic for today is wills under Muslim law, that is wasiyat. According to Muslim law, the wills are known as wasiyat and the document which is embodying the wills are known as wasiyat nama. Now we can go through the pre-Islamic era. In the pre-Islamic era, the proportions or the part which should be given out as a will is not fixed. It was the freedom of choice of the person, and any portion of the property or the whole property can be given out as a will. Coming to the Islamic era, the portions were fixed, that is, 1/3 of the property can only be given out as a will. It is based on the Quran that the Quran says a person cannot leave his children in the state of begging. So, the person has to give his 2/3 of his property to his children or the legal heirs. So, 1/3 of the property can only given out as a will and not the whole of the property. So, the pre-Islamic era and the Islamic era is different from each other because coming to Islamic era, the portions which can be given out as a will, it's fixed to 1/3 and not whole of the property. Now we can look through the definitions of the will. According to Tabji, the legal declaration of the intentions of a Muslim with respect to his property, which he decides to be carried into effect after his death. According to Durul Mukhtar, will is an assignment of property to take effect after one's death. He there says that wasiyat means an endowment with the property of anything after death, as if one person should say to another, give this article of mine after my death to a particular person. From the above definitions, it's clear that the wills come to its validity after the death of the person who is writing it, that is, the testator's death. Until the testator's death, the will doesn't have any validity. Now we can go through the formalities of a will. According to Muslim law, there are no definite formalities for the will. The wills, according to them, can be in oral or a written form. The only thing in writing a will to make it valid is that the intention of the testator must be clear. That is not essential to be oral or written. It can be oral or it can be written. It can also implied or expressed. Now we can go through the case of Mazhar Hussain versus Boda Bibi. In this case, the testator wrote a letter before few days of her death, and the court held that this letter is valid as a will because in this letter the intention of the person is clear. So based on this case, it was held that there is no sufficient form of the will and the intention should be clear. The only thing is that the intention should be clear. Now we can look into the Muslim law of will and Indian Succession Act. According to the Muslim law, a Muslim person is governed by the Muslim law of wills, but the other person are governed under the Indian Succession Act. But if a Muslim person is married under Special Marriage Act 1954, the person after the marriage is governed under the Indian Succession Act. Whether the will is made before or after the marriage also, the person is governed under the Indian Succession Act and not the Muslim law of will. Now we can go through certain essentials which must be followed to make the will a valid one. The first one is the testator must be competent to make the will. A Muslim person of sound mind and a major can make the will. A person who is unsound and write his will in that unsound period and after that he becomes sound mind, then the will become a valid one because it comes to play that when the person is sound minded, he gets a chance whether to revoke or not to revoke it. But if this person is sound minded now and becomes unsound for a longer period of time, then the will becomes an invalid one because he doesn't get a chance to rethink or whether to revoke or not to revoke it. Now we can go through the majority. The majority in this case can be checked based off two things, that is Muslim law of majority and the Indian Majority Act. The Muslim law of majority says that a person is major at the age of 15. But it also says that it is applicable only in the case of marriage, divorce and divorce. So, the majority in the case of will is based on the Indian Majority Act section 3. That is, the person is major only by attaining the age of 18 years. But if the person is guard by a guardian who is appointed by the court, the majority is only at the age of 21 years and not at the age of 18. Now we can look into the will of a person who has committed suicide. The Sunni law says that a person will who committed suicide is also valid. But Shia law says that a will made by a person who had done any act towards committing suicide does not become a valid one. But if the will is made before doing any act towards a suicide, it's valid. In a case, a person who wrote a will and after that he poisoned himself and committed suicide. But in this case, it was held that the will is valid one because while writing the will, he doesn't has committed any act towards committing the suicide. Now we can look into the competency of the legatee. A bequest can be made to any institution. According to the competency of legatee, the person can make the will to any person who is capable of holding this property. The person can be of any age, sex, creed, religion, or it can be an institution also. The bequest can be made to a non-Muslim also. But the person has not be hostile to the religion. That is, he doesn't want to necessarily say that it's right, but he cannot say that the religion or the applicability of the religion is wrong. That is, the person who is non-Muslim, but he should respect the religion. Now we can go through the bequest to an unborn child. According to Sunni law, it is valid only when the child is born within the 6 months of creating the will. But Shia law says that it's valid even after the child born after the longer time of gestation. Now we can go through the bequest to the testator's murderer. According to Sunni law, whether the death is intentional or unintentional, the murderer doesn't get any property. But the Hanafi law says that if it's validated by the relatives, the property can be given to the murderer also. But Shia law says that the will is valid if the murder is unintentional and the will is void if the murder is made intentionally. The bequest can be made to a charitable object or charitable institution also. Now we can look into the subject matter and its validity. A property which is giving out as a will should be in the nature of that it can be transferred. The property which is giving out as a will not necessarily should be existed at the time of making the will, but it has to be in the existence at the death of the person, because at the death of the person who is making the will, that is the death of the testator, the will become a valid one. So the subject matter should be in existence at the death of the testator. The testator can be make a will of the property to which he is the lawful owner. He cannot make a will for the property of another person also. Now we can go through the legacy must be within the limits prescribed by the Islamic law. According to the Islamic law, a person can make the will only for the 1/3 of his property. That is, for example, if person has 1000 rupees and he has a debt of 50, and when he dies, the funeral cost 50 rupees. So, first he has to be paid out, that is debt and the funeral. That is 1000 minus 100, that is the rest of the property is 900. Among this 900, only 1/3, that is 300, can be given out as the will, and rest, that is 600, 2/3 of the property, has to be given out as the legal heirs, that is for the legal heirs. Now we can go through the case of Ghulam Muhammad versus Ghulam Hussain. In this case, a person writes a will to the legal heir itself, that is 1/3 of the property by the will he gets, and as he is the legal heir of the person, the portion of the 2/3 of the property also will be given to the person. Now we can check the exception for this 1/3 rule. According to the Hanafi law, more than 1/3 of the property can also be given out if the heir accept. If the heirs of the testator accept for giving out more than the 1/3 of the property, it's an exception for the 1/3 rule. And in the cases where the person doesn't have any legal heirs, that is testator doesn't have any legal heir, it's an exception to the 1/3 rule, and the 1/3 rule doesn't exist. Now we can check the revocation of the wills. The revocation of the will can be in 3 ways. First one is expressed. The person can express his will to revoke, that is by words. It can be written, oral, or he can write even a letter for revoking his will. The next one is implied. That is, for example, the subject matter itself doesn't exist in this situation. It's an implied that the will is revoked. The third one is subsequent will. For example, today the testator makes a will and next day he makes another will. It's implied that the previous will is revoked and the later will, that is the will which is made later, exists and the previous will is revoked. So these are the three ways which the will can be revoked. Now we can look into the deathbed wills, that is mercy ul maut. In this case, a person can make a deathbed will and it's validate in the conditions where the apprehension of the death is immediate, the fear of death, and the illness must not be for a longer time such that the patient doesn't get used to it. In these conditions only, the deathbed wills are valid one. But the old age is not considered to be equivalent as the deathbed wills, and the above discussed conditions should be there to validate the will as a deathbed will. These are the things which are regarding to the wills under the Muslim law, that is wasiyat. Hope you all understand the topic. Thank you.